A lot of people don't understand what elder abuse is. They may believe that their loved one has experienced elder abuse, but they don't know exactly what it is. And I can give you the legal definition, but I'm going to break it down and give you just an everyday nonsensical version or definition of elder abuse. And elder abuse is when an elderly person, generally they have some type of diminished capacity, they're forgetful, they lack the ability to stand up for themselves to some extent, they're easy to manipulate. And whether that manipulation occurs through someone exerting the free will over the elderly person, or whether it's a threat to withhold medication, food, needs, and preying on their fears. And there's some myths that go with elder abuse that I would like to talk about. Myth number one is elder abuse is always physical. There are a lot of other types of elder abuse. In my practice, financial elder abuse is the number one thing that we either prosecute or defend. It is the most prevalent that we see. Other types of elder abuse are financial, emotional, neglect, sexual. These are all parts of elder abuse. Second myth is legal action is too expensive. That may not be true. Depending on what has happened, on the facts and circumstances, it can be expensive. However, if nothing is done, everything will remain status quo. Family members cannot be abusers. I hear this one a lot. That's myth number 3. And I can tell you that currently, the majority of abusers for elder abuse are family members. Sometimes it's the caregiver, sometimes it's the child who lives with them, and there's a lot of reasons that motivate somebody for elder abuse. Sometimes it's entitlement, sometimes it's, oh my gosh, once mom passes away, I'm not going to have anything, so I need to get everything now. Greed, control, manipulation generally are a lot of the undertones. Fourth myth is the legal process is quick. What is quick to you and me is not quick in a court process. But if you work with experienced counsel who does this type of litigation every day, they can help explain the timelines so that way you go into it with reasonable expectation. Myth number 5 is elder abuse is very easy to prove. I saw him do X and he did Y and it resulted in it. I saw him, manipulate my mom and I was there when she signed the documents and she hadn't eaten in 5 days. Elder abuse is much more subtle. Somebody can believe their case is straightforward, but you still need evidence. What you know is different than what you can prove. And when you do an elder abuse case, you have to have evidence. Now that evidence can be inferred. If A and C happened, there is an inference that B did as well. Myth number 6, that the elderly victims will be forced into court, is not necessarily the case. If somebody lacks capacity, the court isn't going to force them to show up in court. A lot of times the court will appoint an attorney to represent that individual in the proceedings. Myth number 7, only physical evidence counts. That absolutely is not true. With financial elder abuse, sometimes with neglect, with emotional elder abuse, sometimes there's no, they're not bruised, they're not going to the hospital with gashes on their forehead because they were pushed. But a lot of the evidence can be financial. It could be medical records, it can be bank statements, it could be getting a copy of the checks, who is signing the checks. Did they have a long-standing attorney with a long-standing estate plan? Or verbally telling individuals, this is what I want it to do. And then all of a sudden, as they get older, there is a new estate plan. That can be elder abuse. Myth number 8 is only the elderly person can initiate the case. And the belief is that unless the elderly victim comes forward, nothing can be done. That is absolutely not the case. A lot of times the elderly person is scared to come forward. Sometimes, depending on the cognitive ability, they don't even realize that they've been abused. They've been manipulated and fed so many lies that they believe the truth that their abuser has fed them. Family members can initiate a case. It depends on facts and circumstances, but very rarely is the elderly person initiate an elder abuse case. Myth number 9, it's a family matter and we shouldn't involve the courts. What this allows is the abuser to get away with abusing and continuing to abuse. What I have seen in my doing this for almost 20 years is at times if this individual, the abuser, has been around multiple family members, it's not uncommon to find out that they took Aunt Gloria's estate, had the will and trust changed so that they inherited, and it disinherited Aunt Gloria's family. They've done this a couple of times and now they're doing it to your parent. If the courts don't get involved, what happens is the elderly person's legacy, everything that they put together during their lifetime, falls away, and so the abuser is able to either change the estate plan, retain all the assets that they wrongfully took, and it is at the detriment to all the other family members. Myth number 10 is all lawyers are the same. You just need a litigator. For this type of litigation, you need somebody who does elder abuse law, who does it day in and day out, and you're looking for a litigator. You need a very specialized type of attorney. If you believe that you have been the victim of elder abuse or your loved one has, give us a call. We can help explore your options. Some of your options may include litigation, but they might not. And we can have a personalized conversation about you and how to rectify the matter.